Good morning, everyone. Just going to give 1 second for folks to be able to join here. Good morning. Thank you for your patience. Well, again, good morning, and thank you for tuning in. I'm California Attorney General Rob Bonta. I'm joined by two of my amazing fellow attorneys general, Colorado AG Phil Weiser and Massachusetts AG Andrea Campbell. And we are here to announce a lawsuit. Our coalition of 22 attorneys general have filed against the Trump administration, challenging the U.S. Department of Education's attempt to weaponize the Public Service Loan Forgiveness Program to target Trump's political enemies. For nearly 2 decades, the bipartisan Public Service Loan Forgiveness Program has made working in public service more financially feasible for millions of Americans. As of 2024, more than 81,000 Californians have received over $6 billion in PSLF forgiveness. These are public school teachers, police officers, firefighters, librarians, social workers, members of our military, and more. When you consider the list of workers who qualify for this loan forgiveness, it's no surprise that the program was created by a bipartisan, I want to emphasize, bipartisan Congress. We're talking about people who've committed themselves to protecting our public safety, our health, our well-being, people committed to teaching our children, keeping our communities functioning. This program has helped government and nonprofit employers, including the state of California, recruit and retain skilled employees who want to serve the public good. People who so badly want to serve their community that they're willing to pursue jobs with a mission, even though they typically pay significantly less than jobs in the private sector. Now, Trump and Department of Education Secretary Linda McMahon want to bestow the secretary with the unilateral, seemingly unchecked power to take away loan forgiveness from dedicated public servants by deeming their employers to have a, quote, substantial illegal purpose, end quote. A multi-billionaire Trump loyalist empowered to pull debt relief away from public servants who are counting on it. Let's call this what it is. Empowered to pull the rug out from under hardworking public servants, 911 dispatchers, EMTs, nurses, special education teachers, disaster relief workers, sanitation workers, and more. People who were promised their school loans would be forgiven if they did their part by working in public service and paying down their loans for 10 years. So let's be clear about what's really happening. Trump and McMahon want to reward loyalists and punish those who dare to speak out against him, to force us to bend to Trump's whims and bend the knee. This is just the latest example of Trump weaponizing our government to wage his culture war. First, he weaponized our schools, hospitals, military. Now he's coming for hardworking people who've devoted their careers to doing good in the world. Trump and McMahon have no legal right to impose this rule and break the government's promise to the American people. This rule directly violates the Administrative Procedure Act, the APA, and defies Congress's direction under the Higher Education Act, which clearly states that government agencies and nonprofits are eligible employers without exception. That means the administration can't exclude an eligible organization just because it provides legal services to immigrants, or provides gender-affirming care to minors, or participates in legal diversity, equity, and inclusion initiatives, or engages in civil protest and the right to assembly, constitutionally protected rights. They can't cherry pick which public service employers qualify or which don't. The vague rule issued by the Department of Education opens the door for Trump to target any government or nonprofit organization it sees fit, as long as McMahon deems they have a, quote, substantial illegal purpose, end quote. An entirely subjective criteria with no further clarity, no guidelines, no guardrails for what exactly it means, and no basis. These programs that they are seeking to attack are not illegal. If allowed to stand, this rule would create widespread uncertainty and could deter student borrowers from pursuing a path in public service at all. And I don't blame them. They wouldn't be able to trust that the debt relief their government has promised them will actually come through. That's why it's important to keep your promises. You can be sure that would severely limit government and nonprofit organizations from being able to recruit and retain skilled employees. This new rule would betray millions of Americans who were promised debt relief. It would crush the dreams of students who want to leave the world a better place than they found it. It would weaken institutions that uphold our democracy and serve our people, and it would drain the public sector of talented workers. This rule doesn't serve the American people. The only person this rule serves is Donald Trump. Public service is a calling. No one goes into it expecting great wealth. They do it because the work matters. They care. They have a mission. They are mission driven. We should be applauding and rewarding those who dedicate their careers to serving their communities. We should do everything we can to open the path to public service for all, no matter how much money they have. And we should absolutely ensure that the federal government makes good on its promises to the American people. This rule is a disgrace, and most importantly, it is illegal. So I've got one message for Trump today. We've got one message for Trump today. We will see you in court for the 46th time in 41 weeks. And before I turn it over to my amazing colleagues to say a few words, followed by an opportunity for questions, I want to acknowledge my fellow attorneys general who are co-leading the lawsuit, in addition to AGs Campbell and Weiser, New York AG Letitia James. And I want to thank the public servants at California DOJ who've worked hard to put this lawsuit together. They don't work at DOJ for the limelight or the riches. They do it for the mission. They are true public servants, and I want to recognize them. Thank you to Daniel Osborne, Callie Wilson, Barney Eskandari, Nick Akers. With that, I'd now like to turn it over to my incredible colleague, Attorney General Campbell.
Thank you, AG Bonta. Delighted to be here with you and AG Weiser, and of course, co-leading this also with AG James. I'm grateful for our collective leadership. For decades, the Public Service Loan Forgiveness Program has enabled talented, service-minded individuals to build careers helping others. When Congress created this program, they made a clear promise. If you devote at least 10 years of your life to serving people, that is, teaching our children, for example, protecting our communities, caring for the sick, or serving in government, our country would honor you by forgiving your remaining student debt. This promise was not a handout. It was a pact to recognize those who put purpose over paycheck. Because unfortunately, those who work in government or in the nonprofit sector are often paid far less than their private sector peers. In fact, state and local government employees earn on average close to 20% less than similarly educated private sector employees. And let's be clear, when Congress created this program, they guaranteed loan forgiveness to anyone who works in eligible full-time service jobs. They didn't carve out exceptions, and they didn't give the executive branch the authority to leave people out of the program because of a political agenda. Yet today, we find ourselves watching the same tired script we have seen from this administration over the last several months, overstepping their power and undermining our Constitution. The Trump administration is attempting to change the rules to target and punish state governments and organizations that it disfavors, leaving those who dedicate their life to helping others stuck in debt. With this new rule, they're threatening to punish those who work for organizations that participate in activities the administration disagrees with. Activities like protecting the legal rights of immigrants, providing gender-affirming healthcare to transgender youth, promoting diversity, equity, and inclusion, and engaging in political protest. Despite what the president claims, none of these activities are illegal. In fact, they make our communities stronger. If allowed to stand, this decision would have severe consequences across the entire country. Countless public workers would suddenly lose eligibility for the PSLF program through no fault of their own. State and local governments would face staffing shortages and higher turnover. And the cost of maintaining essential services in sectors like the healthcare system or K-12 education system in our respective states would surge, leaving states in an impossible situation. Not to mention the immense pressure states and organizations would feel to comply with this administration's cruel and extremist policies to avoid retaliation and maintain their ability to be part of the loan forgiveness program. This power grab is unlawful and it's un-American, plain and simple. Today, I'm proud to join this incredible coalition of AGs in filing a lawsuit against this administration and asking the court to declare that this new rule is illegal and to hopefully stop the Trump administration from ever enforcing or implementing these unlawful restrictions. We intend to be successful, and we will certainly keep working hard on behalf of our constituents. I'm proud not only to stand with my colleagues as we continue to do this work, I'm really grateful for our co-leads in this state. And now I'd love to turn it over to Colorado AG Phil Weiser.
Thank you, AG Campbell. Thank you, AG Bonta, for your leadership and partnership, and obviously AG James is with us. Last week, we went to court because this administration took the lawless action of playing political games with people's hunger. They withheld funds from the SNAP program in violation of the law. We secured relief in that case because we had strong merits in that case. Today, we once again go to court because this administration is playing political games and taking lawless action. Holding back public service loan forgiveness is against the law. It's wrong, and we're going to stop it. This public service loan forgiveness is a legal promise, as my colleagues noted. In Colorado, just from October 2021 to May 2024, close to 18,000 public servants, they had their student debt forgiven. That's $1.2 billion in Colorado. Our teachers, our nurses, our law enforcement officers, our state government employees, and more serving the public. We made a promise to them. We need to keep it. To undermine this promise, as this administration would do, is just appalling. It's bullying. It's a political game. We're not going to stand for it. Let me talk about three parts of our case and why we're confident we can prevail against this lawless bullying action. First, consider the statute. AG Bonta talked about it. Let me put a fine point on this. In the statute, Congress defined the category of public servants, and they said all employees who work for state government, federal government, local government, except members of Congress, are eligible. The executive branch cannot get away with this power grab, undermining the role of Congress, whose judgment governs here. That's one reason why this rule is blatantly illegal. Number two, it's an affront to federalism. Our Constitution makes this point clear. States have a sovereign role. We have employees who are protected by this loan forgiveness program. But what is this administration saying? That they can actually override states and their democratically elected decisions because the education department decides something might be illegal? That's not the way our system works. Our states decide what our employees do, and it is not something that the education department should lightly subvert. And that's what they're trying to do here. It's a textbook example of arbitrary decision-making. It's illegal, and they don't even try to explain the basis for such a decision. And the third point I want to highlight, and my colleagues have made it as well, is this administration is trying to chill policy initiatives it disagrees with. That's just wrong. As was mentioned, gender-affirming care of legal adults, it is not a substantial illegal purpose, as this rule would suggest. It's healthcare. It's legal in Colorado. It is part of our standard of care. And to threaten those who provide legal healthcare or advocate for it is wrong, and we're not going to allow it to stand. I'm sorry to say this administration is lawless. They are bullying. And we are forced again to bring basic legal challenges because this administration acts as if they're above the law. They are not. And I know I speak for my colleagues when I say we will continue to fight for people, to uphold promises made to them, like this public service loan forgiveness program, like the SNAP program. And we're going to defend the rule of law in the face of administration that continues to ignore it. Thank you. We welcome your questions.
If you'd like to ask a question, you may do so by using the raise hand icon at the bottom of the screen. You can also submit questions through the Q&A feature also at the bottom of the screen. Please state your publication when we call on you. First question comes from Eric. You are now unmuted.
Thank you, Eric Ublocker with Courthouse News Service. I was just wondering if any of you can address the coordination between this lawsuit and the lawsuit that was filed also this morning by private plaintiffs and local governments challenging the same rule. Thank you.
I'm happy to say a few words here, AG Weiser and Bonta. We see that lawsuit as actually being complementary. It also includes the city of Boston that is standing up and stepping up for this program, given the effect it would have on folks who work for that administration and lifting up the harms as we all described. And also we're stressing to folks that here in Massachusetts, we have over 25,000 people that have received forgiveness under this program. It would have devastating impacts, not just for the state, those serving our children and teaching them, those caring for our elders, but also for municipalities. And so this separate lawsuit complements the very lawsuit we're filing here today. And we are grateful for the continued collaboration, especially with our municipalities.
And I might just add broadly that more watchdogs on the block holding this administration accountable and making sure that it follows the law and does not act lawlessly and sues when they are injured and they have standing is better. And in our SNAP case, last week, we had our own AG lawsuit with 26 states bringing a case, and then there was a private plaintiff's lawsuit as well, and cities as well, as a second lawsuit. We got 2 orders last week that found that the Trump administration was acting unlawfully when it came to improperly withholding contingency funds and other funds for SNAP benefits in the United States. So this is very common. We welcome it. More individuals looking and holding the Trump administration accountable is good for all of us.
Next question comes from Dave. You are now unmuted.
Okay. Yeah. Good morning. So this is for Attorney General Bonta, a little bit off topic. But tomorrow, of course, is a big election, Prop 50 here in California. And there will be the presence of federal election monitors. And I was wondering about your concerns about any possible election interference from those monitors or from National Guard troops, and what the rules are exactly about how those monitors can work.
Thank you for the question. And I'll say we welcome transparency in California with respect to our elections. There's nothing to hide. We have safe elections. We have secure elections. We have accurate elections. We have reliable elections. So while we do welcome transparency, and you will see a great deal of it at the polls, there will be representatives from the Republican and Democratic Party, from nonprofit groups like League of Women Voters, from the Secretary of State's office, from my office, in addition to each county's registrar of voters representatives. So it'll be filled with eyeballs and members of the public, all wanting the same thing: transparency and openness and reliability, and they will get that. We do not welcome interference. This is the Trump administration. Trump himself has tried multiple times to interfere with lawful elections. He has asked the Georgia Secretary of State in the 2020 election for more votes to change the result of a lawful election. A court found, and so did a congressional committee, found that he participated in an attempt on January 6th to overturn the result of a lawful election. He's trying to get rid of vote by mail. He issued an executive order to suppress voters' votes and their right to vote that we blocked in court. So this is an administration that interferes with elections, and we cannot be naive to that. We need to be clear-eyed. We need to be sober about that. So we have our own observers deploying tomorrow to keep an eye on these federal election monitors to make sure they stay in their lane. If they stay in their lane, no problem. And what is their lane? They can sit back, be quiet, observe like everybody else. That's what monitors do. They cannot intimidate voters. They cannot try to prevent voters from exercising the right to vote. They cannot physically touch and manipulate the equipment for voting. So that's what I mean by having them stay in their lane. They're welcome to observe and not interfere. There's nothing to hide. In fact, we feel they will be convinced of what everyone in California knows to be true, that these are accurate and safe, reliable and secure elections. So, and then with respect to the Guard, there are clear rules about officers and armed people not being allowed to be near the polls. We are prepared for that possibility, among many others. We've looked at all the things that this Trump administration could do on Election Day. We're ready for all of them. And we're ready to deploy immediately should there be any unlawful actions or any improper attempts to suppress the vote of Californians who just want their voice to be heard and participate in an election as is their constitutional right.
Great. And then I would like to ask just one question related to today's suit. For the three AGs, what is the cost for the student loan forgiveness program, and how many people in your various states, in your three states, would be affected in this program?
I can start. In Colorado, I can tell you over a 2.5-year period, it was close to 18,000 people are getting the benefit of loan forgiveness. So obviously, if you want to do the math and figure that out per year, it's on the order of 7,000 or so people a year are getting this benefit. The nature of this rule is imprecise by design, to scare as many people as possible, to give people fear that they might not get it, which means they'll have the maximum harmful impact. I don't know of those 7,500, which of them are going to have their loan forgiveness threatened, but they're all going to be worried about a rule that is, again, vague and set up to punish enemies. And if President Trump and Linda McMahon were able to say, we think the state of Colorado is lawless, all state government employees, whether you're working in our highway patrol as a state trooper in Colorado, whether you're working as a firefighter dealing with wildfires, that's just the sort of bullying that we're not going to allow. This rule is illegal. It's harmful. We don't know how much money they're trying to save exactly. I think they may have had some estimate, but it's wrong because it's breaking a promise.
And I would just add here in the Commonwealth of Massachusetts, between the year of 2021, the January of this year, we had 25,000 workers that sought loan forgiveness and received it. And these are school teachers. These are folks who serve our elders. These are folks who work in healthcare, the nonprofit sector, who also work in government at the local level, the state level. And these are hardworking folks who had to, of course, be in the program for 10 years and consistently make payments to be eligible for this forgiveness. It's not a handout. It's folks that worked hard. And it's our way of saying we honor their service, especially knowing they make lesser than those in the private sector, peers and colleagues in the private sector, by giving them this forgiveness as designed by Congress.
And I'll just add for California that as of last year, 2024, over 81,000 Californians had been granted the PSLF forgiveness with a value of $6 billion. And as of this July, nationwide, 1.25 million people have received over $85 billion in PSLF forgiveness.
Great. Thank you, all three of you.
Next question comes from Patty. You are now unmuted. You have to unmute yourself as well.
Unmute. There. Now can you hear me?
Yeah. Hi, Patty.
I'm so sorry. Can you help the rest of us, all of us, to understand what is actually happening with the federal court ruling about SNAP benefits and how that's going to affect our states? How quickly can that ruling take effect? How soon will SNAP benefits be available to people as a result of this ruling? And is it nationwide? Does it affect all the states?
Do you want to start, AG Bonta?
Go ahead.
I'll just start. First of all, I'm grateful to my colleagues here and those who are not on the screen with us for collective leadership in fighting to protect SNAP benefits and food stamps for folks who desperately need it. Children are most vulnerable, seniors on fixed incomes, people with disabilities. These are folks who are struggling even as we sit on this Zoom because they don't have their benefits flowing through the month of November. And so what we learned today, just a little while ago, and all of us are still in the weeds, but what we did learn is that this will be nationwide relief. The president and the administration have responded and said that they will tap into funds to cover SNAP benefits for the month of November. And let's be clear, they created the delay in the first place. We had to file a lawsuit to get them to move. And I'm grateful that they moved. And what they said to the court today is that they will partially fund SNAP benefits for the month of November, and that they will tap into the SNAP Reserve Fund, but not Section 32 funds or other resources, which they could absolutely do to ensure that folks actually have full benefits for the month of November. This is a political choice by the Trump administration not to. And what's worse is by doing partial payments instead of full payments, which we're calculating what that is as we review their response, it actually will create more of a delay, which we're also trying to assess what that delay will be, because it's more complex to do partial payments than if they just fully funded the program. So we are responding to our constituents with the hopes of getting them SNAP resources as soon as possible, but making it crystal clear to them that the partial payment choice, political choice and policy choice by this administration will unfortunately keep them without full payment. And we hope, of course, to change that through further intentional collaboration with the court, but also, of course, pushing the Trump administration to do more. And I'm happy to answer more questions, Patty.
Thank you. I appreciate that. I live in a community that has access. We are the gateway to Rocky Mountain National Park. We have tremendous numbers of federal workers who are on furlough. So this is really very important to us here in Colorado.
Thank you.
I might just add also that this is unprecedented. SNAP is an entitlement program. All eligible recipients are supposed to receive funding, and the Trump administration is choosing to only partially fund some. So they are deliberately starving some hungry Americans, and when they don't have to. And this will be the first time in the history of the United States in this program that this has happened. We believe they should use all available funds to fund everyone's SNAP benefits. They're choosing not to, and honestly, it's disgusting. It's dangerous. It's damaging. We believe it's illegal, but that's the proposal they made today. I'll also add that to get SNAP funding up and running for recipients who are already on the program, it takes about a week. So there's always a delay from the time that the Trump administration decides to pay someone until they actually get the food. And these are folks who are hungry, and every day matters. And it has a very damaging impact the more delay there is.
Thank you so much for your information.
Yeah, Patty, I'll just add that particularly in Colorado, we care about one another. And these actions of taking people's food away or threatening to forgive the loans that public servants have, it doesn't strike us as normal. And we can't become numb to the way this administration operates. We have to continue to see this as A.G. Campbell put it, un-American, as abnormal, as wrong. The rule of law means you treat people fairly under the law. Both these cases, the SNAP case we've been talking about and the public service loan forgiveness, these are laws that this administration is choosing not to follow because it wants to harm people and put fear in people because of some political gain. That's just wrong. We're stopping it in court.
That was the final question.
Thank you, AGs Weiser and Campbell. Honored to do
Thank
this
you.
with you. Thanks everyone for joining us today.
Bye, everyone.
Take care.
Take care.
Bye-bye.